Okay, welcome back to copyright. Today I'm going to have a very brief lecture about the concept or requirement of fixation for copyright protection. So as you'll recall, copyright can only protect original works of authorship, but it also only protects original works of authorship that are fixed in a tangible medium, with the caveat that they have to be fixed in a tangible medium for more than a transitory duration. In other words, they have to exist for at least some period of time, although it can be a pretty brief period of time in many cases. So what does it mean to fix a work of authorship in a tangible medium? Really, it just means to make a copy of the work from which you can perceive that work. And that could be a copy in really any medium at all that one could perceive the underlying work in question from. So it doesn't matter how you preserve the work, it only matters that you preserve the work. So say, for example, you create a literary work like a book or a story, you could preserve that by writing it down by hand. You could also preserve it by typing it. You could also preserve it by inputting it as a computer file, or for that matter, you could preserve it by reading it aloud and creating an audio recording. All of those would be fixation in a tangible medium. Copyright law doesn't care about how you fix the work in a tangible medium. It only cares about that you fix the work in a tangible medium. Okay, so we're going to kind of break this into two questions. First off is what kinds of fixation exist for long enough to count as fixation? And second, uh, what do we mean by fixation, and why do we have it in the first place? So in the MAI Systems v. Peak computer case, really what this involved was a relatively early computer terminal, sort of like a mainframe with terminals, as I understand it, kind of networked together. So something we take for granted today, but was really high tech at the time in question. And what happened was that MAI was making these computers that needed servicing. Of course, MAI offered computer servicing services, but they were expensive, and their competitors or other companies were offering the same services, but for lower prices and for a wider range of systems. And so P Computers was going to people who purchased MAI systems and saying, hey, we'll provide you with servicing as well, and our prices are presumably less expensive than MAI, and maybe we provide better service and whatnot as well. Well, MAI's argument was that, look, this is actually copyright infringing because we own a copyright in the software, the operating system of our computers. In order to use those computers, you have to turn them on. And when you turn them on, that copies the operating system into the computer itself. Therefore, by turning the computer on, you are necessarily reproducing a work of authorship, the operating system of the computer, onto the RAM, or random access memory, of the computer itself. Now, Congress and the courts had previously wrestled with this problem when it came to computer users, because of course copyright is indiscriminate about who it applies to. And they sort of wrote into the statute a limitation on the scope of copyright ownership in software to say that the purchaser of the computer that needs to use the software in order to work is not an infringer by virtue of turning on and making a copy, because they need to do that in order to use the computer. So really what P Computer was doing here was, in a sense, saying, look, we're just servicing the system. We're doing the same thing that the user does in creating a copy in the RAM. You can't service the computer without turning it on. How can we be an infringer? But the court created a distinction, essentially, and said, look, the users are licensees of MAI, and they're protected by the statute and by these exceptions. Peak isn't. And so when Peak creates the copy by turning the computer on, then Peak is an infringer because it isn't included within the scope of the license or within the scope of the statutory exception. So Peak kind of fallback argument was to say, well, this really isn't a fixation because the software copy only exists so long as the computer is turned on. And once we turn it off, the random access memory is turned off and the copy disappears. That's not existing for more than a transitory duration. So we're not infringers. And the Ninth Circuit wasn't buying it, right? It said that, well, the copy's going to exist as long as you leave the computer on. That could be for a considerable period of time. And it's not merely transitory, right? You are, in fact, making a copy. The copy exists and you're using the copy. Therefore, you're an infringer. Okay. So fast forward to the Cartoon Network et al. Versus CSC, really, Cablevision case. What happened here? Well, we see the kind of transition from cable broadcasting or kind of cable transmission of television and movies to what we know today as sort of like kind of contemporary television, which is, watch whatever you want, whenever you want it. People were used to having to watch television programs and movies when they were actually being shown by the cable company. I know probably sounds incredibly inconvenient today. And there was this innovation, which was the creation of digital video recorders that could automatically record and play back television programs for you. Well, that was all well and good because it relied on previous Supreme Court decisions saying that consumers were permitted to create recordings for the purpose of time shifting, watching the programs that were more convenient for them. We'll talk about that issue later. Suffice it to say that VCRs, video tape recorders, and digital video recorders operated by consumers were considered legally acceptable and non-infringing. The problem was that Cablevision had introduced a new technology in which they were actually operating servers that were recording the materials that consumers wanted to save for later, rather than consumers operating it on a machine at their homes. And they had to do various kinds of technical things in order to make that technology function properly. Among other things, they had to have what's known as a buffer in the system. In other words, the Cablevision system was constantly retaining about 1.5 seconds of material from everything that was being shown that would enable consumers to kind of essentially start up their own recording and get the entire program. So the core question in the case here was when the Cablevision system created this automatic buffer, was Cablevision creating a copy of the works of authorship, the television and programs and movies in question, and therefore infringing the copyrights in those works. And the argument from the movie studios was, well, look, we've got this MAI case out there that says that creating a copy for technical purposes, if you don't have a license to do it like the consumers would have, is infringing. Therefore, Cablevision must be an infringer. Therefore, we must be the prevailing party. And the Second Circuit here looked at the MAI case and said, well, MAI didn't really deal with a situation like this one, right? I mean, at least in MAI, Peak was intentionally turning on the computers and intentionally creating copies and actually using them for something. And here, the Cablevision system is just constantly creating and overwriting this buffer. The only time the buffer ever gets used for anything is when the consumers actually need it. And so the Second Circuit looked at this circumstance and said, well, this really is kind of transitory. It only ever exists for 1.5 seconds, except when the consumers want to use it. Therefore, we don't really think MAI is controlling, and this should be treated as not a copy because not really a fixation, right? It's just kind of an evanescent, kind of temporary kind of recording for the purpose of the technology itself and not a recording for the purpose of creating a recording. So you might ask yourself, are these two cases really consistent with each other? And why do you think they might have come out differently? Why do you think the Second Circuit sort of looked at a similar circumstance and said, this isn't the kind of situation where we think copyright infringement should attach? And what was the really underlying nature of the dispute in both of these cases, right? Was this really about copyright, or was it more about competition and who was going to be able to charge who for using these works in a way that consumers found appealing? Okay, well, let's think about what we mean by fixation in the first place and why we have a fixation requirement in relation to the Kelly v. Chicago Park District case. So what happened here? An artist named Chapman Kelly, initially a painter, but ultimately became better known for his plant installations, was permitted, really approached by and kind of worked with the city of Chicago to install a large-scale installation on the Chicago lakefront called Wildflower Works. And it consisted of two oval-shaped gardens planted with wildflowers that were designed by Kelly, but kind of organically changed in various ways. Very popular initially, lots of press through the city and so on. But gradually, the kind of new administration, the city moved on. They wanted to do something else with that part of the waterfront, and the city informed Kelly that they were going to be reducing the size, essentially eliminating the gardens that he had created. In other words, we got a new vision for the space, and it doesn't include Wildflower Works anymore. Kelly was very upset and filed a copyright infringement, really Visual Artists' Rights Act infringement action against the Chicago Park District. Essentially, the Visual Artists' Rights Act says that works of visual art have a right of integrity and can't be destroyed. But the underlying question here, the important question for the purpose of our class discussion today, was really whether or not Kelly's work, Wildflower Works, was protectable by copyright in the first place. And ultimately, the lower court, the district court, said that no, it wasn't protectable because it wasn't an original work of authorship. In a sense, Kelly created a garden. Gardens aren't protectable, therefore no copyrightable work of authorship. But the circuit court kind of disagreed on the method, although it agreed on the ultimate outcome. Essentially said, look, the requirements for originality are really minimal, right? So yes, other people have created gardens, but Kelly did something to create something that has some kernel of novelty, right? He fit the garden to the space. He thought about the oval pattern. He had ideas about, what flowers would go where and so on and so forth. That's probably enough for originality because that's a really low bar. But we don't think that this is a work of authorship fixed in a tangible medium, right? Because it changes all the time, right? I mean, the plants grow and Kelly can't control really how the plants grow. They grow in their own ways. And it's not the same at one moment as at a different moment. Therefore, the lack of fixation in a tangible medium means that there is no copyright in the works of authorship in question. So one thing I would really encourage you to reflect on is whether the Seventh Circuit was really thinking about this properly, and what really is the nature of the work in question. In other words, is the work of authorship the physical garden that Kelly planted on the lakefront in Chicago, or is the work of authorship the intangible expression that was embodied in that particular garden, but could be embodied in a different garden as well? In other words, how should we think about copyright ownership? How should we think about the subject matter of copyright here? And what, if anything, does fixation. Tell us about this. I mean, after all, is Kelly's work fixed in a tangible medium? What are you looking at right now?